Hello visionaries, welcome back to my channel. My name is Maresa Talbert. I am the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. So I have a serious question. Do you have $263,000 to pay for the rights to use your legal name, the name you were given at birth? Well, when you don't read your contracts, such is life. And this is not a drill. This really happened to someone and we're going to talk about it. So let's jump right into it. There's a wedding dress designer named Haley Paige Gutman who gained significant recognition over the years for her wedding dress designs. She was the head designer for Haley Paige Bridal, which was a division of a company called JLM Couture. Her wedding gown designs were known for being whimsical and romantic and intricate, and she's also been featured on shows like Say Yes to the Dress. However, Haley was involved in a legal dispute with her employer, JLM Couture, over the rights to her name and her social media accounts. You want to know why? Because Haley signed a bad contract. Let's take a look at some of the contract provisions that were a part of this 3.5-year-long lawsuit. Here, we have the court's ruling that was decided on May 8th, 2024. Let's take a look. Section 9A is a covenant not to compete, which we've discussed previously. Currently, non-compete agreements have been banned in the United States by the Federal Trade Commission and will take effect September 2024. Section 10A, exclusive right to the designer name. So let's break this down. This section grants an exclusive worldwide right and license to JLM Couture. So the right and license grants JLM Couture the right to use Haley's name, her legal name, as the designer name. And they also specify that not only can they use her actual name, they can use any variation of her name. So Haley by itself, Haley Paige Gutman, any variation. The right and license is also exclusive, which means that no one else in the world has the right to use that designer name, which is Haley's actual name, not even the designer herself. And worldwide means that JLM Couture can use her name globally and is not restricted to any geographical part of the world. Not the United States, not Europe, not Canada. They can use it worldwide, literally. Section 10B talks about trademark rights. Here you can see that Haley irrevocably sells, assigns, and transfers all rights, title, and interest to JLM Couture that now exist or may exist during the term and for a period of 2 years after. So if we look back to the top of the opinion, the term of the employment contract began on July 13th, 2011 and ended on August 1st, 2022, plus 2 years. So a total of 13 years. So any intellectual property that Haley already owned as of July 13th, 2011, or that Haley acquired through August 2024, which has not even come about yet, JLM Couture owned outright based on these contract provisions. That's not all. The trademark shall, in perpetuity, which means forever, be the exclusive property of the company. Haley Paige shall have no right to use her name in connection with any fashion without the consent of JLM Couture. And this provision allows JLM Couture to rent out or license out Haley's name to a third party, make money off her name, and do it all without her consent. Do you see this? If you think that you haven't signed a contract with these same or similar provisions, the lie detector test determined that is a lie. It is way more likely that you have signed a contract that share these same sentiments, except the intellectual property that you gave away was not your given legal name. It was your business name. It was your genius business concept. It was your movie script. It was your graphic design, or it was your creative invention. Are you following me? Let's keep going. Section 11 talks about designs and intellectual property. Now, I done told y'all about this work for hire clause. It's a clause that says a creative work made by an employee that is protectable by copyright law is owned by the employer, not the employee. So if Haley created a wedding dress sketch, that sketch was owned by JLM Couture, not by Haley Paige Gutman. But let's take it one step further. If the creative work does not fall under copyright law, this contract provision that Haley signed says that Haley irrevocably assigns or gives ownership to her employer. Now, I've talked about this in several videos. I've talked about it in my video about hiring an independent contractor. I've talked about it in my video where I'm talking about whether to rent or sell your intellectual property, i.e. assign or license your intellectual property. I've talked about it in many other videos. Specifically, if you hire a blogger to write a blog for your website and the contract does not have an assignment clause, that blogger owns the article, not you. So that blogger can give you the article, but can also tell you when you cannot use it any longer and to take it down from your website. Similarly, if you hire a graphic designer to design a logo for your business and you don't have an assignment clause where that graphic designer gives you the rights to the logo they created for you, that graphic designer owns that logo, not you. And that graphic designer can sell that logo to 10 other businesses and you can't do anything about it. And lastly, we see here a moral rights clause. Now, I've talked about moral rights in several of my videos as well. It is one of two rights attached to IP ownership. One right is economic rights, which is the right to earn money by licensing out your intellectual property. The other is moral rights, which is the right to control how your IP is used in relation to how it aligns or conflicts with your reputation. The example that I've given in the past is the right for a music artist to decline the use of their music in an adult film. So now that you see these contract provisions and how they can be played out in real life, will you believe me now? I've been trying to tell y'all, and you want to be hard-headed. You still out here signing contracts because you think you can't afford for a lawyer to review it. You still out here making business deals without a written agreement. You still out here hiring independent contractors without an assignment clause. And you wonder why you paid for a custom logo that 10 other people are using. Now will you listen to me? All right, let's stay focused. Let's talk about what happens to Haley next. So after entering into this contract, Haley opened an account on both Pinterest and Instagram bearing the handles Miss Haley Page. This is now trademark infringement because JLM Couture owns the Haley Page trademark. You see how this works? What do I always say? A contract tells you what you can and cannot do in a relationship. She signed over all her rights. She no longer owns the rights to her legal birth name as it relates to wedding dresses and wedding dress designs. And the long story short is JLM Couture, Haley's employer, sued her. Now, there's a lot of other details and time passed within this whole dispute. I'm giving you the main breakdown concerning IP and contracts. But the bottom line is that Haley's employer wanted to enforce those contract provisions because Haley signed saying that she agreed to them, that she understood them, and that she would abide by them. And she didn't. They wanted the right to those social media accounts bearing the handle Miss Haley Page. And guess what? A judge granted a preliminary injunction, which is an order for her to stop using them until this lawsuit was completed. So let's fast forward. On May 31st, 2024, Haley and her previous employer, JLM Couture, entered into a settlement agreement. Yay! That sounds really great, right? However, in this agreement, Haley agreed and had to pay JLM Couture $263,000 to get the rights back to her name, her legal name, Haley Page Gutman, her social media accounts, and the rights to now make bridal fashion. Here is a video that she released just about 2 weeks ago.
I never thought announcing myself would be an announcement in itself, but today it is, so here it goes. I am Haley Page. I'm Haley Page! Haley Page, I want to shout it from the rooftops. I feel like a kid on Christmas. After 3.5 years, I've recently been awarded back my personal Instagram, TikTok, and Pinterest accounts, all under the original handle name at Miss Haley Page by the district court. This ruling is so meaningful because my case has likely set positive legal precedent and case law for anyone and everyone who uses social media both personally and professionally, which I know is a lot of you. Thank you for welcoming me back and sharing in this excitement with me. There is something else I wanted to share, something I prayed and hoped and dropped a lot of pennies in random fountains for, but frankly didn't think was going to happen for a really long time. The legal dispute that I have been involved in the past few years is officially settled. A lot of deep breaths. I owe a tremendous debt of gratitude to my intelligent, kind, resilient, and super duper hardworking legal team at Haynes Boone and Lewis Brisbois. I'm so relieved that there has been respectful resolve for all parties, and most certainly wish my former employer and opposing counsel well. And there's more. Another thing that came from this settlement was the opportunity to own my intellectual property. I'm gonna keep it together, I promise. I am proud to share that I have recently and solely acquired the entire IP portfolio of Haley Page. This includes the entirety of my designs, catalogs of work, trademark, copyright, domains, any other forms of intellectual property, even my sketches. This is something I never expected to be reunited with, let alone own, but I could not be more humbled to simply hold my art, and moreover, have the ability to share it with you on my own terms.
So the question is, do you have $263,000 to pay for your name? I didn't think so. Save yourself the money, save yourself the trouble. And don't forget, this legal battle was finally settled after 3.5 years. So can you imagine the attorney's fees that Haley has already paid out to defend this lawsuit from her previous employer for 3.5 years? I'm going to say it's probably upwards of at least $500,000, if not more, to then settle out by paying $263,000. Save yourself the money, save yourself the trouble. Go ahead and schedule you a consultation with Talbert Law Office if you need a contract drafted or reviewed. Or you can go over to the TLO Marketplace and get a contract that you need for your business transactions. TLO won't cost you your name or $263,000. Don't forget to like, comment, subscribe, and share with a friend. And as always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. And I'll see you in the next video. Bye.